Good evening, everybody. It's a pleasure to have Manish with us today. I will briefly introduce Manish. Manish is currently working with Deloitte in risk advisory. He's a director with Deloitte. He has over 15 years of experience in risk advisory, which also includes experience with Big Fours. He has handled varied clients with their overseas presence and operations across various countries and sectors. Manish has experience in servicing large business units in the sectors of engineering, energy, automobile, FMCG, consumer business, etc. Manish is an MBA with specialization in finance and risk management. He is also a member of IIA. Manish is currently pursuing his PhD in corporate governance from Symbiosis Pune. Manish has been guest speaker and has contributed articles for various forums and institutes. Recently, he also contributed an article in IIM Monthly newsletter. Let's look forward to hear from Manish today. Manish, over to you.
Thank you, Madhvi. Thank you, Nikhil. Thank you, Madhvi, once again for the introduction. I hope I'm audible to everyone.
Yes.
Madhvi, can you hear me? Okay, great.
Yes, yes.
Once again, good afternoon, everyone. Hope everyone is safe and we are ready to make most of the time we have today. And before I delve into this topic, what we are going to discuss around the data protection or data privacy, let's first understand that what has been happening so far as the data protection is concerned in the context of India around us. So I've captured whatever has happened in the last year or so. And if you can see on the slide as reported by the CERT, which is a nodal agency for the central government, year 2019 alone witnessed some 3 lakh odd number of cybersecurity breaches, and most of these breaches were in fact trespassing the privacy or the personal data related stuffs of the Indian citizens in the context of India. Some of the major cases also I have captured here so that we understand the gravity of the situation at this point in time in the context of India, and why really was there a need for a bill like this, what is currently there in the parliament for their consideration and the approval. So the first case, if you see, somewhere at the beginning of year 2019, last year, SBI in fact was caught. One of their server in fact was breached, and some 3+ million of their account holders details were in fact compromised. Some unwanted messages were in fact sent to SBI customers, and it was a huge embarrassment for the brand like SBI. A month after, in fact, again in 2019, we also must have observed or seen in the media space the case about the Just Dial, wherein 10+ crores personal information was being compromised, and it was in fact being sold on the darknet. Unacademy, which is very closely, in fact, associated with the likes of Facebook's as an investor and some of the other marquee names, was also caught off guard in year 2020, somewhere in the month of May, just after the lockdown, wherein again 2.5 crore personal information of their users was in fact being hacked and sold to a darknet. The last case I'm highlighting here, the reason I'm highlighting FireEye is because they in fact are into enterprise security, and despite that, in fact, even in 2017, 7+ million their users who are primarily patients as well as doctors, their data was being hacked, and it was also then ultimately sold on darknet. So the topic we are going to discuss over here is not primarily from the law perspective, but also most importantly from the perspective of the brand as well as from the consumer trust. The reason why I chose to highlight each of these cases here as a use case is because if you correlate these in the real life scenario with our basically companies or our clients who we serve as internal auditors, it is definitely a cause of a concern, a matter of, in fact, a grave, a concern that what would happen to the consumer trust, their experience, and more importantly, to the brand like State Bank of India, Just Dial, Unacademy, or a FireEye. So given the context, I thought of that. Let me just first of all, show you all that, how grim the situation look like so far as the Indian data privacy for the Indian consumer is concerned. So let's move on, get into the nitty gritties of the bill and understand that what exactly this bill entails. But some of the key highlights of this bill I just wanted to capture on this slide. So initially, this bill, in fact, was introduced before the general public for their comment in year 2018, July. And after having, in fact, taken everybody's opinion and their comments on board, the bill was again tabled in December 2019 in the Parliament. Unfortunately, because of the COVID and some of the other pressing, bills, this bill could not get through. But what I heard last as I speak here, the bill is now expected to be tabled in the upcoming budget session. And those of you who track the privacy related matters in the context of India must have seen that the Joint Parliamentary Committee for last week or so has been in fact meeting almost all the big giants who have been handling the personal information of Indian citizens. And as I speak, in fact, today since morning, likes of a Google as well as a Paytm has been facing the ministers and explaining the kind of checks and balances they have in place to make sure that the personal data of Indian citizen is not compromised. So who this bill applies to, that's the most important content for each one of us to understand even before we apply the uh, the uh, the elements of the bill. So it would apply in fact to all government agencies once enacted and once in fact this becomes law. It would also apply to every company. This is sector agnostic. So irrespective of whether it is a B2B business model or a B2C business model, this bill would also in fact cutting across all sectors would be applicable for the companies. This bill also be applicable for foreign nationals as well as foreign companies dealing with personal information of Indian citizens for the purpose of any business or for the purpose of a profiling. The whole agenda or the intent of this bill, what through bill this in fact authorities want to ensure that the bill is not going to give any leeway to in fact the data principle. I'll explain who is data fiduciary. That this bill is no longer is going to be an option for any data fiduciary or the processor and can no longer be ignored. So in fact, this is something which is going to be forced upon those who are dealing with the personal information, and hence it becomes imperative for almost every organization to revisit the risk acceptance criteria they may have with respect to the data governance or the data privacy related stuff, and they may have to then rejig the entire privacy and the data protection framework at whatever maturity scale they may have in their respective organization. So let's understand some of the key definitions of the bill before we actually look at the provisions and how it is going to impact each one of us as internal auditors. First and foremost important is the data principle. So the way it has been defined in the bill, that any natural person, any human being who the personal information relates to has been provided in the bill as a data principle. So any other living object, be it animals or let's say any other living object, is out of the ambit of this bill. It is only for a natural person and their related personal information. Who has been defined as a data fiduciary? That any person, any government agency, any company, either in the jurisdiction of India or outside, who determines and processes the information of a natural person has been identified as a data fiduciary. Then there is a concept of a data processor. So anyone who on behalf of data fiduciary, if processes the information of a data principal or a natural person, has been identified or designated as a data processor in the bill. This is extremely important for all of us to understand that what is personal data. So the way it has been defined, that anything which can be directly or indirectly help anyone to identify a natural person has been classified in the bill as a personal data. And if anything relating to a natural person, if can be used for the purpose of a profiling, can be attributed as a personal data as per the provisions of the bill. The one which is extremely important is this sensitive personal information. In fact, this is something which is going to have a huge repercussion on almost every company. The way sensitive personal data has been, defined here. So anything of a natural person, be it a financial data, health-related data, their official identifier, their sexual orientation, biometric data, these all has been identified or classified as a sensitive personal data. The reason I have color coded here the financial data with a different color than rest of the stuff which I have highlighted over here, because if those of you who are tracking the privacy matter closely would have heard so far that this is something which is an inspired version of a GDPR, which is Data Protection Regulation of UK, applicable for not only companies which are operating in UK, but also any entity which is dealing with the personal information of the UK citizen. So in the context of India, the bill which has been tabled in the parliament is the truly inspired version. The reason I'm saying truly, to an extent of a 90 to 95% provisions which are highlighted in the GDPR is very much in fact adopted or proposed in the bill, which should soon hopefully be act. The reason I highlighted a financial data here, because this is something which is a departure from the GDPR. So if you read the GDPR definition with respect to the sensitive personal data, financial data is something which has been kept out of the ambit of GDPR in the definition of a sensitive personal data, but that is not the case so far as the Indian Data Protection Bill is concerned. And this is something which is going to be this is something which is going to be quite onerous on almost every company. It is also important to understand the companies who are also in, let's say, a B2B business model, business to business model, and not into B2C business model. For them also, something like a health data of their employees or the biometric of their employees is going to in fact definitely make them a thing that how exactly what sort of safeguards they need to have in place to make sure that they do not fall other side of the compliance requirement. Moving on to the some of the other important definitions. So what really has been classified as a processing is that any information related to a natural person or the data subject related to, let's say, a collection of their information, recording of their information, storage of their information in your basically setup, any sort of alteration of this information, any sort of a erasure or a destruction is classified or defined as a processing and will amount to processing when obviously things will be looked at by the authorities in the context of a compliance. So this is also very important for us to understand that whether something which in the given context of organization is being collected, processed, and also archived, whether falls into this category or not. Next three definitions are around, there are safeguards which has been in fact provided in the bill, that what kind of safeguards are expected with respect to the natural persons or the data principles information. So be it anonymization, de-identification of their personal information, or re-identification. So there is a provision for that as well. And last but not the least, so far as the definition is concerned, the breach is also something which has now been very clearly explicitly defined in the statute, that any unauthorized accidental disclosure or the acquisition or sharing of the natural person information or its destruction will be construed as a data breach or the personal data breach. And anything which compromises either the confidentiality of the data collected of a natural person or its integrity or the availability, that is also something which is going to be in fact attributed as a personal data breach. This is exactly again inspired version of what has been defined under GDPR. Now, what would be important before I actually get into the real provisions and how exactly it has to be looked at in the context of the internal auditors, we also need to understand that if you look at this bill and if you compare the GDPR, like I said, that it is in fact a true copy of a GDPR, but in the context of some of the other mature economies like the US or for that matter, in fact, Canada, this is far more comprehensive than what you would see in the other developed economies like US or Canada. because there, if you see, their governance is structured is in fact is structured in such a well manner wherein that they have a hybrid model, wherein they have in fact the national law, then they have a province specific law, and then they have a sectoral law. All these put together in fact then enforces individual sectors or the companies or individual to protect the personal information of the information. Whereas if you look at the GDPR or the Indian Data Protection Bill, it is a wholesome, comprehensive, and this is sector agnostic. This applies to almost every company, every sector, every state, and there is no real demarcation between that. This very provision would be applicable to FS. This provision would be only applicable to telecom, and and so on. So that's an important, in fact, a differentiating factor between the way act like HIPAA, which is basically a US-based, a privacy bill with respect to the health insurance and the sector, or a GAP, which is generally accepted privacy principles of the Canada, or a GDPR or Internet Data Protection Bill. So that's an important, in fact, a difference between each of these bills of separate economies or the countries. Now let's understand the construct of this bill. That how does this bill look like? I'm not getting into the detailed part of that, how many total number of chapters or the clauses they have, but what is definitely important to understand is some of the salient key features of this draft bill. So this bill definitely provides, in fact, an authority which is going to be known as a Data Protection Authority of India, or a DPA, to not only oversee the compliance with the provisions of this bill or act in time to come once implemented, but also enforcing the provisions of this bill. So that's one of the significant feature of this bill. The second significant feature of this bill is that it is not only in the context of a companies or the individuals who are collecting data, but this also provides a lot of empowerment through individual rights to the individuals or the natural persons, that how they can exercise their rights with respect to the data protection or the protection of their personal information. So that's another key salient feature of this bill. And last but not the least, this is beyond a territory of India. So any company or an individual who happen to in fact deal with the personal information of an Indian citizen for a business purpose or for the purpose of any sort of a profiling would also fall under the ambit of this bill. So that's another key salient feature of this bill. So what happens? What is the deterrent? What if companies do not, in fact, comply with what is expected, of them? So this is the, in fact, the deterrent or a kind of a penalty which has been provided in the bill. So anybody who is caught, obviously, on the non-compliance side, would obviously ultimately be liable to pay to the extent of either 15 crore INR as a penalty, or 4% of the global turnover. So one needs to be mindful that this is a global turnover. This is not a turnover in the context of India for the Indian entity. So if there are in fact subsidiaries who have their parent entities elsewhere, for the purpose of a penalty, the global turnover will be considered. So likes of a Facebook or a Google or some of the other global giants who in fact are operating in India, Uber or a Ola or Amazon, they are the ones who in fact have to be also mindful of the kind of implication or the deterrent which has been proposed in the bill. So why would anyone pay? Means what is the definition which has been given, that what category of non-compliance, if they found to be in fact be part of, it would be imposed. So anybody who in fact non-complies to the obligation of a data fiduciary defined in the bill, this in fact amount or this percentage would apply to that entity or a person. Anybody found to be processing any personal information without consent of a natural person would in fact again sit under this category of a 15 crore or a 4%. If anyone caught in fact processing the data of a children, which has been defined in the bill, anyone below age group of 18 years without their parental consent or their sensitive information, will again be penalized under 4% or a 15 crore of a criteria. Any non-adherence with respect to the data security safeguards which has been in fact suggested, again sits under this very category. And the last one is related to the transfer of personal data outside India, without defined procedures, which has been in fact provided in the bill, would also fall into the 15 crore or 4% category. And then there are less severe penalties for some of the individual non-compliances or the data breaches. If company fails to take a prompt action or notify to the DPA, there are separate in fact provisions for that as well. So up to 5 crore or 2% of the global turnover can be imposed on the companies for the non-compliance. Now let's understand that what are some of the key requirements which has been proposed in the bill before we get into the individual natural person's rights and the responsibilities of the companies and what we are supposed to look at when we look at as an internal auditors, either in the capacity of a consultant while we are advising our clients, or as an assurance provider when we look at the entire framework for any of our client or any of our our company. So scope and the applicability part is something I've already touched upon, so I'm not again getting into it, but what would be important to understand that who this bill would not apply to. So this bill would not apply to any natural person who uses the personal information for the household stuff for their purely personal or the domestic purposes. So whatever, let's say CCTV camera or whatever biometric machines, etc. If anybody has installed for the personal purpose, domestic purpose, only for the household purpose, is out of the ambit of this bill. This bill also does not apply to any law enforcement agency, any national security agency, or courts or a tribunal. The bill would also not apply when the data has been processed in the interest of a prevention, detection, investigation, or the prosecution of any offense. So any antisocial element cannot in fact use the bill and the related provision as a safeguard that without seeking his or her consent, things will not be collated and data will not be processed for the purpose of investigation. That is the underlying assumptions, and because of which explicitly, in fact, this provision has been introduced in the bill, that anything to do with, in fact, the prevention of any sort of antisocial, activity will be out of the ambit of this bill. Now, one of the ask, in fact, that what and what will not constitute as a lawful processing, because this is what in fact defines whether we as an enterprise or individuals complying with the provisions of this bill or not. There are 6 principles, and these principles also are in fact the inspired version of what you would otherwise see either in a GDPR or maybe in a CAP or maybe in a HIPAA or a GBL Act. These are different, in fact, of privacy-related acts of a world over. But principle remains same, and hence it is important for all of us to understand principally that what is expected of a data fiduciary or a processor, and then as the case may be, or the legislation applicable in the context of our clients or our companies, we may have to tweak each of these principles. But what I have captured over here, that what exactly would constitute lawful in any given law or any given basically ask by any authority world over. So the first ask is that whatever data you capture as a company or an individual from a natural person has to have a purpose limitation. So you have to in fact define the purpose for which you're collecting that information, and you have to make sure that that very purpose is not in fact being breached, and that information collected for this very purpose has not been used for something else. So for sake of example, if suppose I happen to check in into, let's say, ITC group of hotels, and if ITC as a part of my check-in process, if suppose happen to capture my personal information, they do not under this bill would have a right to use that information for any future branding or any sort of a promotion or any sort of a cold call to me as a natural person, or they also at the same time cannot share my personal information with any of their group entities to do any sort of a campaign or any sort of a profiling on me. So that's extremely important. So the purpose has been in fact limited, that for whatever purpose you are letting your user or your natural person know that you're collecting this information, you have to restrict your uses of the data for that very purpose. So that's one of the principle. The second information or the second principle, which in fact falls under the lawful processing, is a data minimization. So what is expected here from the data fiduciary as well as the processor is that you collect only to the extent you require. No need to collect whatever you feel like collecting. You restrict your collection only to the extent anything which is just justified and which is important for your basically purpose, you only collect that information of a natural person to that extent. So let's take an example in the context of, let's say, anybody hiring any HR person in any organization. Let's say if expects any candidate to fill their interview form, we generally have a habit of, in fact, asking for too many details which generally are not being used at the time of at least evaluation. Let's say, be it their blood group, or let's say their residential address, or let's say their PAN card detail or a Aadhaar detail. So this is also something very, in fact, judiciously needed to be studied, that what exactly is required for the purpose of in fact, any transaction of a natural person, and data fiduciary as well as data, in fact, processor is supposed to minimize the data collection to that extent. The next element is with respect to the accuracy. So here, the responsibility, in fact, would lie with the data fiduciary or the processor to make sure that whatever information they have collected, that remains up to date, that remains accurate, and it does not mislead, about the natural person or their personal information. And this updation has to happen in the time-bound manner without any unnecessary undue delay. So this is again quite, in fact, onerous responsibility on not only data fiduciary but also on the processor, that they have to ensure, and they would be held liable if a data maintained with them of a natural person is subsequently found out to be inaccurate, or let's say a dated data. The next principle is with respect to the storage limitation. So the ask here from the data fiduciary or the processor is that you also, in fact, while collecting the data, you mention that for what duration you require this data. So if suppose the duration defined is that if there is an employment relation between a company and the person who is employed, if that duration, let's say, ends at the termination of employee, and if there is no subsequent, in fact, law which restricts deletion of that information of a natural person, then you have to make sure that at that point in time the storage, in fact, is ceased, and you do not any longer hold the information of a natural person. So this is also something which is needed to be thought through and built into the entire framework in the context of a company. Uh, the last one, which is again extremely important, the lawfulness, fairness, and the transparent manner of collecting the information. So you have to make sure the way you collect the information, you collect it lawfully, and you will have to demonstrate it that how you have collected. So there will not be any longer a situation wherein you all would have, in fact, come across a real life challenge that you happen to, let's say, make an entry at a society's entrance, or maybe some a corporate building's entrance, and subsequently that data is being sold to some of the telecallers, and they keep on, in fact, calling you for some of their services or the products. That is not going to be the case any longer, because the idea here is that whatever you collect lawfully, you collect fairly, and you collect in a transparent manner with due information of the natural person or the data subject. Lawfulness is something which is not explicitly identified or, in fact, included in the bill. But if you look at the interpretation of the bill, this again, in fact, addresses that it has to be a lawful collection. And hence, though it is not explicitly part of the PDPB bill, but it is, in fact, an inspired version of GDPR, because under a GDPR, lawfulness is explicitly mentioned and expected of a data fiduciary or the processor to ensure the data collection happens in the lawful manner. Last but not the least is basically the integrity, confidentiality, and the availability, which I spoke earlier, that the data fiduciary and the processor would be responsible to ensure the integrity of the data, maintaining the confidentiality and the availability. So what is important here for us as a professionals to, when looking at the framework or the related, in fact, the building blocks in any given organization, or let's say our companies, whether each of these elements, through whatever frameworks we have put in place, or whatever data security safeguards or the IT safeguards we have put in place, whether each of those safeguards fulfill each of these conditions or not, or these principles or not, would be important for us as a professionals to look at, evaluate as a part of our assurance mandate. Now let's understand, like I said, that one of the salient feature is actually the rights of a data principal. So irrespective of what we as a entity do, or in fact the data fiduciary does or the data processor does, there are certain rights which has been provided to data principal. So if you as a data fiduciary or the data a processor not choose to in fact abide by the law, you will be forced upon some of those provisions to basically comply, or to you will be in fact answerable to a DPA or to the authorities, because the data principal will make sure that you abide by it. Otherwise, obviously, he has all the rights to take you to the court or to the DPA or to the authorities to make sure that you comply. So the first and the foremost one is right to access. So whatever you would have collected from the natural person, it is in fact the duty, you will be duty bound as a data fiduciary or processor to confirm to the that personal data to the data principal in the summarized form that what all processing activities you are performing on the personal data collected of a data principal. So this is one of the right a data principal or the natural person has, and if you do not abide by it, then obviously he has a recourse available with him. So copies of a personal data processed by the data fiduciary, the data principal or the natural person has a right, in fact, to demand and get a copy of it. And what is important here, that some of these information upon request has to be provided free of charge. You cannot, in fact, charge anything from the natural person to provide him this information. What is also quite onerous, in fact, for the data fiduciaries as well as for the processors, is that if suppose you happen to distribute or disseminate this information to the other data fiduciaries or the processors, you as the principal data fiduciary will have a responsibility to collate all those informations for data principal, and you would be held responsible to provide that information to the data principals. So this is also quite onerous for every company who collects the information uh, uh, of a natural person. What is in fact is still quite sketchy in the bill, if I see, is with respect to the overall time given to the companies to respond to these in fact requests of a natural person. If you look at the GDPR, under GDPR, data fiduciary or the processor has been given a timeline of 30 days to revert back to them with these requests. And if they are unable to do so, they are supposed to in fact notify to the data principal as well as the authorities about their inability and the total time they would overall take to pull out this information. This is still quite sketchy in the context of India, and we are hoping that there will be some clarity around this, that within how many days of a time period from the date of receiving these requests, companies would be expected to respond with these information. What is also in fact quite interesting in the bill is that at any given point in time, data principal may demand you to give them their personal information in the portable or the readable, machine readable format, so that if they want to, let's say, port that information from you as a, let's say, enterprise to another enterprise, you are duty bound to basically honor that and provide them in the machine readable format so that they can take it to some other service provider. So especially in the context of, let's say, a telecom players or the financial institutions like banks, etc. If suppose any data principal expects to collate all the information at one place in the machine readable format, uh, it will be in fact a responsibility of a data fiduciary or the processor to provide them that information, which in fact a portable, which can be taken into a competition or any other company for the use of a data principal. The other right which has been given, in fact, which rests with the data principal, is the right to get the information which is there with the data fiduciary or the processor corrected in a time-bound manner. Uh, I in fact clearly recollect a real life in fact challenge when a couple of years back I was moving from my previous firm to join a Deloitte. We in fact are supposed to surrender whatever financial interest we may have in correlation to my previous organization. So one of the financial interest was in fact a credit card. uh, uh, Whatever credit cards I had to surrender, and when in fact I joined Deloitte, I applied for a credit cards, and to my surprise, I was refused to be given credit card by any of the three in fact companies I approached for the credit card. And the reason I was given that I had the a very very filthy looking a CIBIL score, and to my surprise, in my life, I had never defaulted a single overdue payment. When I reached out to CIBIL inquiring about the score which has been attributed to me, I found out that there are across India 16 Manish Kumar appearing under my name, under my basically profile, and most of them have defaulted. Somebody has taken a two-wheeler loan, somebody has taken a four-wheeler loan, somebody has taken a housing loan, farm loan, and whatnot. And at least half of them have defaulted, which in fact puts me under the blacklisted or the red flag category, and I was not in fact. And believe me not, it took almost year and a half to convince every financial institution who had given that loan to different Manish Kumar across India to have my in fact name deleted from the CIBIL to be able to again eligible to apply for any sort of a loan or the credit card. Now, what is going to happen? The reason I narrated that story is because after this bill comes into existence, this in fact this will be quite onerous for the data fiduciary as well as a processor like your banks as well as a CIBIL to make sure that on a time bound manner they correct your information as soon as they receive the correction request. So users like me will not have to wait for another year or so to justify to get their information corrected. So this is again very important uh, empowerment which has been given in the hands of the data principal. Uh, this provision is also in fact quite interesting that once the collection has lived its purpose, data principal will have a right to in fact request formally to have their information with the data fiduciary or the processor deleted or forgotten. This is again comes with the caveat that so long as that deletion or forgetting does not breach any legal requirement for a company, the data fiduciary or the processor is a duty bound to make sure that your information in their system is erased and that very natural person is forgotten in your infrastructure. What would be in fact interesting to see once this bill becomes an act and people start rolling it out for the implementation, that how are you going to in fact look at some of the archival processes companies have which they have been following for ages now, some of the data which they might have collected several years back and they might have archived it, how they're going to retrieve, because retrieval itself is going to be in fact a phenomenal cost for every company. So this is something which is going to be again quite catchy for companies to deal with and come out with the solution. And in fact, this is the point which is still being deliberated with authorities, that what sort of expectation authorities have from the companies to make sure that the information they are collecting during the course of their business are at a given point in time, the time mind manner, either deleted or forgotten. Now let's look at, once we have understood now whatever rights have been given to the natural person or to a data subject or a data principal. Now there are certain duties and the responsibilities which has been let down for the data fiduciary as well as a processor. So some of those key responsibilities I have let down here, and it will be important for us to understand because these all will ultimately translate into your work program as an internal auditor to see whether a company or the client of yours, wherein you are going to conduct audit, whether remains compliant to some of these expectations or not. So one of the, in fact, ask for the legal processing or the legal basis for the processing, like I highlighted earlier, is the consent. Whether you have sought the consent of the natural person or not will be extremely important for companies to make sure that they have a processes, checks and balances to make sure that they seek the required consent from the natural person while collecting the information. Data can also be processed of a natural person if there are any legal obligations to be fulfilled. So that's another legal basis for companies to process somebody's a natural person's personal information. If companies or the hospitals, let's say, are treating a patient and require their personal information for any medical emergency, or while basically they attend to somebody's life which is under threat, they can still in fact use that as a legal basis for processing the personal data. They don't have to wait for the consent of that individual, so that is also provided and classified as a legal basis for the companies. And in fact, companies can use this avenue as well to justify if they've collected during the course of a medical emergency while treating a natural person or a data principal. To provide a medical treatment or a health services, this is something which can be considered as a legal processing. Protecting the safety of individuals during a disaster. So during a natural calamity or the situations like COVID, if let's say NGOs and some of the other organizations, if doing anything to make sure that the disaster or the natural calamity if they're dealing with, and during the course of that effort, if they happen to collect a natural person's information, this is something which will again be considered as a legal basis for the processing of a personal data. So there is a provision in the bill. This is in fact interesting. This is somewhat a departure, in fact, from the GDPR. So companies, I'm sure that a lot of you must be wondering that what about the employment purposes? So yes, if you are in fact employing somebody, uh, you need not to in fact seek explicit consent of your potential employee. The employment purpose itself, in fact, work as a legal basis for processing natural persons of personal information. And any other reasonable purpose, which in fact is articulated by the regulators or the DP on a time basis. That is also something. So this is something which is obviously kept open-ended, and authorities will have a choice to in fact amend it as and when need arises. Last one, which is not explicitly in fact highlighted over here, but since here in the context of India, legal obligation has been given as a legal basis for processing somebody's personal data. The performance of a contract, unfortunately, is not explicitly called out in the bill. So one need not to assume that while performing the contract, the entities will have to go back to seek a formal consent. No, the understanding is not that. That is something indirectly will be falling under the purview of a legal obligation. But if you look at the GDPR or if you look at the GAAP, which is a Canadian privacy rule, there the performance of a contract has been in fact explicitly called out under the legal basis for processing anybody's personal data. So these are the key highlights so far as the legal basis for processing of personal data is concerned. Now, this is something which in fact I highlighted earlier, that critical personal data must be processed in India. That is the whole intent of this bill. So anybody who wants to in fact send, despite this bill, something outside to their parent entity or to a processor or a third party beyond the territory of India or a jurisdiction of India, including a sensitive information, then there are a lot of safeguards which has been proposed in the bill. So it will be mandatory that you explicitly seek the consent of the data principal before you do that, before you in fact transport this data beyond the territory of India. If you are in fact transferring the data which is in pursuant to basically you discharging any contractual obligation or intergroup schemes which has been duly approved by the data protection authority, you can do it. Without that, one can't. So this is another in fact condition which has been put forth. And the last condition is in the context of there are certain countries, there are certain jurisdictions which has in fact also be included over here. They have not yet specified, but in time to come, those countries will also be called out by the DP or the authorities that if you are sending any personal information to those countries or those companies which has been classified by the DP or the authorities, one would be free to do that. And the DPA has been given, in fact, or has been empowered to authorize the individual request for the transfer of Indian citizens' data to the overseas jurisdiction. So these are some of the, in fact, asks which has been laid down in the bill so far as the international transfer of the Indian citizens' data is concerned. And this is also important for in fact, for us to look at that if at all there is an exchange of information happening of Indian citizens beyond the boundaries of India, whether the underlying safeguards have been put in place to make sure that a company remains compliant to these provisions. So far as consent is concerned, so the expectation from the data fiduciary as well as processor is that you seek the consent which has been freely given. This is very similar to the contractual Indian contractual law requirements, which defines that freedom from any sort of a coercion or any undue influence or any sort of a fraud or misrepresentation. These things data fiduciary or the processor is not supposed to do. The consent has to be sought from the natural person in the free manner, in the transparent manner. The consent has to be very specific and clear, and extremely important that you also have to make sure that you make the withdrawal of the consent as easy as you have made the consent giving to an individual natural person. So it shouldn't happen that once you have collected, you make the natural person run pole to post to make sure that his or her data has been erased, or they basically have been authorized to withdraw their consent for any legal processing of their personal information. So there are in fact a separate category with respect to the children, unlike GDPR, if you see, wherein 16 years of age has been classified as basically a criteria to identify somebody as a children. In case of a children, if any personal data, if companies or an individual intend to process or collect or retain, they're supposed to in fact reach out to their parents. What is also important and quite onerous for the companies here is that the responsibility to verify whether somebody has to be classified as a children or not again lies with data fiduciary or the processor. So they need to verify whether the natural person is a child as per the definition of the law, and if so, they are supposed to reach out to the parents or the guardians of a children or a child to make sure that they give a consent on behalf of the child. What in fact has also been let down for companies like, let's say, a Baiju or some of the other, let's say, First Cry, etc., wherein in fact a lot of kids' data is being collated and also used for the profiling and advertising. There is a concept of a guardian data fiduciary. So those data fiduciaries that operate online services directly to a children's, so they are also supposed to in fact operate, collect and process the children's data under additional guidelines which has been prescribed under the bill. So this is something which has to be additionally in fact looked into when we are looking at the compliance. There are certain conditions which has been let down under the law. So the condition is that when you are seeking the consent, you make sure that things are not implied or inferred. It has to be explicitly given. So far as the sensitive data is concerned. So if you recollect on the very second slide, when I said the health related information of your employees or the biometric related information of your employees in your organization, in the before this bill era, if you have in fact a legal contract or the employment contract to engage your employee or the contract worker, it was assumed that obviously you also have a right to collect their health related information, their thumb impression, or in fact to also capture through a CCTV camera their movement or their in fact movements in and around the plant premises or the office, which is not going to be the case. Since those have been attributed as a sensitive personal information, the explicit consent is expected to be sought from a natural person so far as the processing of a sensitive data or the information is concerned. So there are certain, in fact, protocols which has been let down with respect to the transparency of the requirements. So one of the key highlight here is that while seeking the information, you have to give a privacy notice to a natural person from whom you're looking to collect the data. So that notice has to be in fact in multiple languages so that the natural person can read and comprehend the notice you are giving to him while collecting the information. Your notices have to be as an enterprise a very clear, concise and easily comprehensible. You don't have to make it complicated, and it has to be very easily comprehensible for the natural person to decide whether they want to give a consent or not for the collection or use of their information. Uh, these notices are mandatorily supposed to be provided at the time of the collection of the information. So companies will not have, in fact, a leeway to say that information we collected at the time of a check-in, check-in at the reception, at the check-in counter in the hotels, and probably the privacy notices will be sent in the room, or it will be sent subsequently through email, through emails, etc., to the natural person. So that is something which will be important, that it has to be provided at the time of the collection. And in fact, the privacy notice also have to necessarily have the aspects related to the grievance redressal. What sort of a recourse company provides to the natural person to get their grievances redressed, what kind of procedures a natural person is supposed to follow if they have any grievance. Also, they're supposed to, in fact, give the information of a data protection officer or the authority of your company or a nodal officer who can be reached out should they have any grievance. That is also something expected to be provided as a part of a privacy notice while you're seeking the information or the consent of a natural person. If you are supposed to or subjected to go through a data trust score, which I would cover in the subsequent slides, that is also supposed to be highlighted as a part of your privacy notice so that natural person or the data subject can make an informed decision whether they would wish to share their personal information or not, because this would also define the credibility of the entire governance mechanism with respect to the privacy you have as an enterprise or individual. So this is also extremely important and needed to be included as a part of a privacy notice and can be looked at. Uh, these concepts I will not delve into because these are mostly for the big data fiduciaries or the data fiduciaries like Amazon or let's say Uber, Ola, Facebook, those who are processing, churning massive amount of personal information and using these personal information for the purpose of profiling. So there's a concept called privacy by design. This is again inspired a version of what has been prescribed under GDPR. That is also, in fact, has been included in the bill. So, like I highlighted, that there is a provision for the Data Protection Authority, and the Data Protection Authority. So, whosoever has been classified as a significant data fiduciary, like I said, that anybody who deals with voluminous or a humongous sensitive information or the voluminous personal information of a natural person, like likes of Facebook, Google, and Uber, Ola, etc., they are supposed to, in fact, uh, to be classified under the new bill as a significant data fiduciary, and they are supposed to register themselves with DPA, Data Protection Authority of India. And DPA, using these four parameters, would decide whether somebody has to be classified as a significant data fiduciary or not, because the some of the obligations or some of the ask or the expectations from the significant data fiduciary is far more onerous as compared to the normal fiduciary or the data protection, and hence there's a separate provision for the SDF in the bill. Then anybody who has been classified as a significant data fiduciary in the context of India has to have necessarily data protection officer appointed. There are in fact guidelines given that who can be appointed as a data protection officer in the context of a company. And what has been also clearly called out that that DPO who is identified by the company has to represent uh, the data fiduciary under this act, and anything going wrong or any representation on behalf of a company has to be done through a DPO, be it, let's say, any sort of interaction with the DPO or the authority, or in fact even with the natural person. This is the nodal agency or the nodal department or the authority who would be held responsible to make sure that this is fully implemented in the context of a significant data fiduciary or the processor. This is again a data protection impact assessment. This is a phenomena which is only applicable for those who are classified as a significant data fiduciary, not applicable to every company. Recording of data processing, this is also something quite onerous, but applicable only for companies which are classified as a significant data fiduciary. So in fact, they also will have to demonstrate and they have to retain the record of all the information they have processed and the kind of safeguards they have put in place to demonstrate to the authorities at basically a due interval or any sort of inspection or the audit, that how they have been processing and what sort of safeguards they have put in place. So that's an additional requirement which is applicable only for the significant data fiduciary. This is quite interesting for us as the audit professionals. So now there's going to be, in fact, another opportunities for professionals like us, that anybody who in the context of India uh, uh, classified as a significant data fiduciary, they must have to submit the annual audit report, audit conducted by the independent auditors as per the statutory requirement, and this audit has to be necessarily conducted by those who have been authorized as the auditors by the TPA, and this report is going to be in fact used in translating obviously your overall score into a data trust score, which I spoke earlier, which is needed to be in fact explicitly highlighted in the privacy notice when you are in fact seeking a consent from a natural person. So this is a significant impact of provision for professionals like us, because this is another opportunity for professionals like us to get into this as well as one of the avenue or the profession. Uh, so if I summarize whatever we have discussed so far, this is something in fact now would allow processing of individuals' data only for the purpose of lawful purpose, and lawful purpose has already been defined now. So there is no leeway for anybody to give excuses that they weren't aware and they happened to in fact buy it from somebody and hence they are going to use it or they were using it. That's not going to be the case. So that's an important takeaway. So the another important takeaway for us is that this bill or the act in time to come is going to compel data fiduciaries to start processing data in India, because the rules are going to be far more stringent for any data, in fact, transportation from the territory of India to the overseas or international geography. The bill will ensure that confidentiality across sectors and won't limit to a particular sector. Like I said, that unlike the US, wherein obviously they have a hybrid governance model, this bill a true inspiration of a GDPR. So this would be applicable across all the sectors. This will be sector agnostic, and in fact, this would ensure that everybody is being measured against the same yardstick. So there's not going to be a separate provision for every sector or the business model. The idea here is that whatever happened in past, but in time to come, in the new normal digital economy or the new India digitally driven economy, the overall impression to basically enhance the India's data sovereignty status in the international market amongst the investors. That's the whole intent behind this bill. So that is likely to in fact improve through whatever has been suggested. And last but not the least, uh, that going forward, all the natural person's data will be collected, used, stored, and protected under the strict lawful guidance which has been stipulated in the law, and data privacy safeguards which companies are supposed to in fact implement in their environment. Uh, Let me just quickly touch upon those of you, in fact, who have gone through one of the article which I recently contributed to the IEA magazine. That was fairly, in fact, detailed in the context of any consulting nature mandate if we get as auditors, internal auditors, or maybe any assurance mandate if you're supposed to undertake. Uh, those, in fact, aspects I, in fact, quite comprehensively have covered in that article. But what I thought that I could not cover because of the sheer, number of pages I was running into, is the aspects related to the internal audit engagements. Otherwise, when we are going to execute in time to come, once this bill becomes a law, what all additional precautions or what all additional checks we need to have in mind before we get into the audit of any business process area going forward, is what I thought of just summarizing over here. The first one is, in fact, the knowledge and the awareness as the professionals that any business process area, once this bill becomes a law, would in fact, if you see, irrespective of the business process area you look at, you would fall into, in fact, the requirements of the bill, and you would in fact also be, as a company or the representative of the company, would be required to in fact uh, comply with some of those do's and don'ts. So hence, what becomes important for us is that the knowledge that what is applicable for your company, the awareness about it becomes extremely crucial and critical for us as a professionals. So what may happen that if suppose all this while as an internal auditors, if you were doing, let's say, HR and the payroll review, or if you're doing, let's say, HSC audit, or you were, let's say, doing a procurement audit. So at our basically whims and fancy and the let down procedures as defined in our basically internal audit charter or the policy or the manual, we used to in fact demand these information. We used to in fact review these informations while during the course of the audit execution. What is going to happen that now we need to, every time we ask for any personal information of a natural person in any given scenario, we need to necessarily go back and check with the privacy champion of your organization or your client, as well as the legal counsel of that client or your organization, to make sure that you don't find yourself on the wrong side and you don't unintentionally end up in fact non-complying to something which is not supposed to be in fact breached as per the new norm. So this is extremely important, that you need to be aware and knowledgeable about everything which has to do with the personal information of a natural person, and seeking the advice at the right time from the privacy champion or the DPO or the legal counsel of your organization before you actually get into the data collection and you get into the actual audit execution. Then applying whatever safeguards which has been laid down in the privacy policy of your organization in your, in fact, way you access the information, you review your information and you report your information. Those safeguards then also needed to be percolated down into your daily work to make sure that you remain compliant to the company's privacy policy under new normal. The next extremely important element is the data security is going to be in fact integral part of your audit planning, execution, and the reporting stages. So what I meant here is that whatever you have been in fact looking at, validating, checking as an auditor, you also have to make sure that wherever there is a basically demarcation between the manual checking as well as the system related checking. If there is anything wherein there is a play for the digital information or system driven information which has to do with the personal information, you have to make your entire plan as well as the execution and reporting along with the IT experts, or let's say a subject matter experts of your organization or your client when you execute your audit. So that's another new normal which I would say for us as internal auditors, which is going to play out in time to come as we handle the personal information of a natural person or the clients or the stakeholders in the context of a company. Last but not the least, the whole objective of having each of these safeguards is to make sure that we as an internal auditor, while executing any mandate wherein personal information of a natural person is involved, we do not end up not complying with applicable law or in the context of our work or in the context of the company we do any audit.